avaayo talikusuula mu ggaali. Abantu nga beeyongedde, Abamerika bazuula n'Abangereza.
Oli bulala olaba oli yajjegeesi ate yabadantenako ddata najakola bivuyange nazeyo buto
Bayira nga yakumponyeza ate tondi bulungi
nawe owulira
yakumponyeza
ejjako badde kuserekera okwekyo jako eyo yange yerako
ng'ogenda kugulira iPhone 20 naye mwe bibanyumira kwogera ng'ogenda kugulira iPhone 20 Desh tolina network mbu tolina network nsooka oggyeko Desh sooka oggyeko kamera yo mbu tolina network tewali sound kati era temugifuna Sport yagambye Sport yagambye full figure tagenda labika ate waali kaso mupya saundi ateredde Muko nyambe nkwajira nkuteeka tana nsoke fulumeko ninga tulina okunoonya emikwano oba tuyagala mikwano nze njagala abantu babe naye si bonna nkugambye amafaananyi g'obadde bakutte notukuvamu yadde omuntu okugamba nti munange ng'olabire ozikuluma naye ojja lwakumuluusa kuwona omusujja omanyi koyinza okuwulira ate Katonda ayisa obubaka bwe mu bantu olaba nze kati sirimbe kamawulire nze nyumya n'omuntu netwawukana naye naye nga embuzi tunyumiza sigirekawo tulinyumiza zefunamu ekyokuyiga buli mulowooza nti abantu banoonya emitwalo banoonya abantu baba bamala biseera naye nga naawe kenyini oli mubi naawe kenyini oli mubi omutima mubi toyagaliza abaana b'abanno toyagaliza abaana b'abaganda bo nga naawe kenyini omutima mubi nga muvundu naye ngaoli awowooza abantu babi tulina okwerowooza twebusaba Katonda atusaasire tutambulire mu kwagala bw'oba olina omwoyo omubi naawe oba okiwulira weesabire Katonda akusaasire omwoyo ogwo gufe weesabire osiibe omwoyo omubi ogutogomu ogwagaliza abanyi ebibe gufe kubanga kyosiga kyokuwuula bw'oyagaliza abaana babanno okumuyagala naawe ojja kubonaabona siribi yankunoonya wendi wamu endi siina wendaga wendi nitiwakambi simanyi
No. Siri mugagga nnyo naye Kristo ndi mulamu ndya n'eyimuwa nebaka ne bukya tunakalira obugagga bingi tufunye emikwano egintegedde ng'omuntu ategeera obukugu awo muwooza sinabirina byakku ebyokulambira ne bizinesi yange weeri naye olina okufunayo time n'ogiwa abantu lwaki mwagala nsimukeranye esimu ningakwasayiteero isi omwana abadde ati bwedda abantu nga bawana simu yange oyagala kukola otya gwe mwana gwe lwaki mwagala nsiramuke muleke mbere mu ddiini yange naye ng'obumu bwetaagisa ambabulire olaba nze gyenkolera gyenayigira obumu zebadde nyina nnyo empisa era nga bamuboogera nga bano abasiru era bamu mu tiktok abamu abagamba oyo omukazi yeegula oyo omukazi agamba bwe nakolanga nababamu nga bewoogera kubanga nzina mbadde nga ndi mwetowaza ebbanga lyonna naye nze bwe nakola omukolo gwange abantu ne bakkiriza nti okuza weyisa obulungi ofuna obulungi okuva eri abantu bansondera ssente nenkola omukolo ne guggwa nga ndi musanyufu nga ndi musanyufu kitegeeza obwetowaze bwange nabufunamu mwe temulowooza mbu kati Hajji ali wano abantu bali wano bangi nnyo ne batu bayisa bikulu Hajji yakisigira Katonda ali mu musasula ne gwe obeereyo mukaadi nogamba nze sigenda waffe nze siziika lwolifiro ne bakulegera omulambo mu nnyumba lwolimanya siga bulungi ogule bulungi ekyo nkigamba nnyo abantu siga bulungi bw'owulira omuzimu omubi oguyingidde mu bwongo bwo gusabire oba musiraamu zuuka ku mwenda osaale ogwo omuzimu gufe kuba oguwulira nga gujja nga bulolaba sirivye nga tunudde mu kamera ogamba ekikazi ekyo bannaaye ogwo omuzimu gusabire gufe buli wolaba munno ng'afunye akalungi olina okumwenya omusiraamu agamba bisimilla nze tenewunya Katonda omuganda yagamba lwoyagaliza mukakitaawo otegezi lwoyagaliza mukamaama wo lutamaama wo ekikazi ekyo bannange kyessaawo naawe wesseewo yagaliza ofune wamma Maria lwotayagaliza mu kirungi kyonna okumaliriza ola naawe oli awo nyettu otunuulira obulogo bw'okukyalo abaloga buli azazibako ennyumba ebbiri ne baloga abaana b'abannaabu tebakulaakulana kati weŋŋamba nti je naliko obugulu w'ekizibu kye gwe nogamba ninamuvuye iziti kivumo kubanga omuntu asuuza mu mwaka mulamba jeno namuwala enti nalisaswa namuwa ne sente nenkera nadda waliwo abantu bannamaliri babafuuka bazola bakulookabe nolaba omuntu mwezi gumu ng'omulaba emirundi era n'omuwa sente ng'omulaba mu maaso go tomubuuza nti okola ddi wamma that is my role, that is my way. Bano abangasseko ebigambo abanvuma abankuba nze amwe lion amwe big more than big obwo bulabbi kibulinaku obwo bujjonkezi bulina kujjonkera jakukuba omukka mayiraaga nze nakanguka
agambye bwajja bakubumuka ekirero ng'ogikubye nnyo nti olako yaliyo ne sikiini yali yadda kukola atana.
Mutabani wa Kasukwali
Kati si balina okuziba binda.
yaleese omulala.
Oli yabadde ku mukulu yabadde amuwata mikolo. Teyakuyisiza.
Twagenda twabadde
Alina gwe yagala.
nati twabadde ku kyalo. Twabadde ku kyalo tebayita bantu.
Yayigadde Mukasa abadde tamanyi.
Ku kyalo tebayita bantu.
Atuyita kwantu. Ekigenda okubeera
Kulwanira content byobeera awo.
era content.
Naye maama abaka banaabeera mu makanzu. Musooke muguleyo ku data awo. Mupiininga awo ennamba awo. Moderator piininga ennamba awo.
Ate kuba ku moderator waaki si lugezigezi. Kikyakola.
Alina opiininga ennamba.
Anti gwe moderator ate kati oli moderator bye bibi.
Wakati ndaba
Kati
data
teekako ennamba wano ogipiininga.
ndabe wano 0759529778. Thank you for update. 0759529778. Good morning to you, Bella. How are you? Network yange kati ejanye. Bettina olimba. kino olimba buli muntu yeetaaga abakozi naye abaana abali akuleesiibwa ati abaana baffe bamanyi baagala byakufunirawo
luba lugendo mpola mpola. Start from one step. Endesho kuba tikiti kituwe bakasamba
ekiro mba neebase
n'ekiro obambo
sibaako kiro
nga kusanga mwe
kinene nnyo baako ssaawa
nya
oba 12 oba oluusi emu nengenda neneebaka paka ssaawa 12 naye kati omutwe gwakanya
eyo bimanyira naye nze sibisobola nade tiktok sigisobola
gwamanyira
buli yali yagala kanoni Hajji omuwasa oyo ayambadde polisi
ajja muwasa
kisoboka yakoowa
naama etaata abatapinga screen mwebale nnyo naye teekeeko ne ssente Hajji Eyakwata I want to see you oyagala kundabira wa ssebo mukama wange you want to see me where kansoddyuke obanga otya kansoddyuke osize otya bwakedde ndi bulungi manager Roni wangoba naye happy new month manager Roni naye sooka onsindikire ku ssente munsindikire ku ssente okola ki mu kooti noonya kontenti senti yo alina okubulookinga gwe tolina na dipi oyo waniino oyogera bya kisiru genda mu mute siraani nakawo nyaga siira kamaama ogamba otya kamaama? Badde embalaga ekiri ebweru.
Namukasa ali bweru. Ali bweru maama. Namukasa ebweru.
Namukasa leero bamuganya oyingira.
Alimedde kuwasobi.
Owaayi manageroni ogamba otya? Wali ntereddeko ku ssente. Deshe, thank you. You are welcome dear. Musajja we. Abantu abali wabweru baweza omutwalo.
Imaamu ate muliraano.
Imaamu ate muliraano. Omu ku basukulu mweyimirira. Olina kusuubira kisa kikyosuubira leero.
Kuguwa ku booti naye. Nze ninde kinabaafu obukyatandika kujja. Nijjo tusuubira tuddayo naye.
kenyini kinaaba kibaddewo inshallah.
Omulamuzi oyo singa ofuna omukisa n'oyogerako n'omulamuzi oyinza mugamba ki?
Mugamba kubyanga oba kubyakaaji
Ku bya Hajji
ojjako mwogerako nti Hajji kiba ekimusuubirwamu si kyali naye nti ekyamuleeta waggulu sikakasa nti kyako kusinzira bwe tumumanyi kubeera nti tuwaayo obudde bwaffe okujja sisuubira nti kiri ekimuvunaano ati yakikola. Birabika ebiseera ebisinga kibeera kizibu omuntu asobola n'okudda ku ludda olumu oba okuba eno eriyo gwatandiitaasi ngamba nti wadde ali ku kituufu nesibira ku ludda n'oyo tubiraba mu bintu bingi naye nga nze omwanya kwange kumanyi omusajja oyo bayiga kuboera nze ensonga zaabwe zaali zitusekeewo mu muzikiti gwaffe naye nga museeri tufe zaali zino si zino naye nga baalinako ensonga zaabwe era omukyala n'azireetako waffe emyaka egiyise mukaawo omutonotono naye era twamaliriza tumusengeze tulaba abe mutuufu yayinza okuyinza okufuna singa omuntu oyo takyusa mu mbeera ezo ekino olwaleero tuliko kati nzize ku muntu gwemumanyi embeera za mukyala gwe ziwadde
Case number 389 of 2024, Uganda versus Alionzi Jamaru, Alliance for Joe.
I'm not aware that the accused person is in court. However, his legal representative is here. The circumstances, I pray that the accused, the matter be under production warrant. But his legal representative comes also.
Prisoner, could he be in the cell also?
No, Your Worship.
Explanation then.
Your Worship, we have not brought them because of space, but they are in the cells.
In the cells?
Yes.
Have you started with the matter? Or
You want to speak the matter is what? Yeah. Can get another place.
Yes, Your Worship.
You explain it, can you put it on record?
Your Worship, the reason we...
I want you to identify yourself and I put your record as what you are telling court.
I am Cadet Principal Officer Fred.
Fred who?
Kenya. Yes, Your Worship.
I already said them. You call it identity off.
Yes, Your Worship.
The other one I can't hear it.
Cadet Principal Officer Frederick Kenya.
Kenya.
Yes, Your Worship.
And then explain that the inmate is a file with the court cell. The cell that court.
Let me confirm, Your Worship.
You have been heard.
You're confirming, Your Worship.
You have the inmate produced on 19th of December. What has done that? We also have this in May and June. You want to January what? You have 14th? Look at your 14th of January, cancel. So we meet next year. Application number 408, 2024, Izerwa Ali versus Uganda. Whoever is that person reporting this matter should be what we have and the one proceeding to be transcribed.
Most of that. May I please your worship? Robert Bautu. I'm appearing jointly with Honorable Muhammad Serebo. Mr. Bima Jamil. Karua Eno.
Most of them.
My Lord, my name has been murdered, so I prefer to give it life.
All the technical authorities. Proceed.
Most of life. My Lord, my name is Timothy Amerit. I am the Honorable Senior State Attorney in the office of the DPP. I appear together with Counsel Zubeda Namugenyi, I beg your pardon. Counsel Zubeda Namugenyi. From Sania Namugerwan Company Advocates. My Lord, the applicant is in court, and this matter was coming up for hearing by the learned judge. In his absence, my Lord, I pray for another date.
Your Worship, we've appeared in this matter several times. The first time we appeared in this court, Your Worship, the court gave us directives. Those directives were to the effect that the applicant will file his submissions.
Now, let us proceed with this matter. The history of the matter is known even as no solution.
Most of them.
And you are saying file submission,
Yes.
which is clear and to all parties. Now, I want to give instructions as to how we should proceed as then.
Your Worship, we are going to move you under that particular provision of the law, but if you're giving us directives, most of them.
The local judge is indeed not available this morning, but he has given directives that we have the suites identified and any other matter shall proceed. So that's the motion and that's how we're going to proceed.
Your Worship, could we add that on the issue of identification of sureties, we could also highlight, since it's for purposes of receiving,
No. Highlighting of submissions?
highlighting just a few segments of the.
I'm not sure to that question. I wanted to hear to take particulars of the suites, period. Those are the instructions, and that's where the legal mandate is.
On that note, Your Worship, then we will move to identify the legal surety as directed by the judge.
Your Honor,
That's what.
yes, Timothy Amerit. Yes, Your Honor. We appreciate the information that we have received. I need, however, to bring to this honorable court the fact that the hearing of this matter is not an issue of convenience, but one of law. And I've well noted that this honorable court will not take on the hearing of the submissions, which perhaps will be done later. Your Honor, that in my view can subsequently be done with the identification of the sureties in the subsequent sitting. Your Honor, under Section 15 of the Trial and Indictment Act, it governs the hearing. Section 15 of the Trial and Indictment Act governs the hearing of a bail application and release of the accused person on bail. And it clearly states that that mandate is squarely of the High Court, and in this instance, the judge sitting as the High Court. The consideration of the bail application, Your Honor, consideration of the bail application, Your Honor, includes one, the applicant lodging the application, the respective counsel, either divine, being heard on the application, the sureties being identified by the court, and certainly the subsequent determination of the application. Your Honor, the law requires that such undertaking be handled by the judge of the High Court. And Your Honor, that undertaking cannot be delegated to a registrar or to any other officer of court. It's squarely a mandate of the judge, and that maintains the integrity of the proceedings. Your Honor, in the Constitution Bail Guidelines, the Constitution Bail Guidelines for Courts of Judicature, Practice Direction, of 2022, particularly rule number 3C, 3D, they require the court 3C, 3D.
Oh yes, if you don't say and, I presume you are so many. 3C and D or 3C? Continue.
Your Honor, I hope to adopt those to 3C and 3D. They necessitate the court to promote uniformity and consistency. To promote uniformity and consistency when considering bail applications? When considering bail applications. And Your Honor, this is not exclusive to the determination of the bail application. This is not exclusive to the determination of the bail application. But it refers to the entire process, right from lodgement of the application what transpires in the course of the application, and final determination. MD requires there is a need to streamline disparities in handling bail application. Streamline disparities. Actually, it says streamline and address disparities in the handling of bail applications. Your Honor, the position of the law and practice is that a judge entertains the bail application throughout, including identification of sureties. The issue of having a registrar receive particulars of sureties is a disparity. In the handling of bail applications. And there is no law that permits a registrar to have that power and mandate. Your Honor, I'm well aware that Section 43(2) of the Judicature Act, Section 43(2) of the Judicature Act provides that where there is no procedure laid out for the High Court in any written law, where there is no procedure laid down for the High Court by any written law or practice, the court may, in its own discretion, adopt a procedure justifiable by the circumstances of the case. That's what that provision says. This provision refers to the High Court sitting and a matter of procedure arises and the law is not clear to that judicial officer. Then that High Court judge will then, in his seat, exercise discretion as the circumstances of the case warrant.
Just put it clear that I'm sitting in the chief of court.
My Lord, I prefer using my words, and I do not want to put words in my mouth. We can say you're seated in a court of a registrar. Simply put. So, my Lord, Your Honor, the High Court is the one to make that determination in a matter of procedure. Now, receiving sureties in the instant case is not a matter of procedure. And it is not even the High Court receiving the sureties, exercising that mandate in itself. It's not the High Court, it's not a sitting judge. Because it is the sitting judge, the High Court, to exercise that right and power. I need not overemphasize, Your Honor, that matters of jurisdiction are creatures of statute. Matter of jurisdiction is a creature of statute and cannot be delegated, not even by an order of court. Matter of jurisdiction is a creature of statute, and it's not delegable or cannot be delegated, not even by an order of court. It's like the High Court telling the Chief Magistrate to handle a murder case. It's an illegality, ab initio. I would wish to draw court's attention to the case of Uganda Revenue Authority. Uganda Revenue Authority versus Rabo Enterprises Limited, Supreme Court Civil Appeal number 12 of 2004, where the Honorable Justice Lillian Tibatemwa Echirifubinza stated that where a court held, I beg your pardon, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandates. Your Honor, I don't see you writing. I pray it's captured even in your report.
Instantly, I asked you on the microphone. It's not out of the book. For a reason that you are being captured verbatim.
Most obliged. I hope this excerpt is not expanded. But it says, the court said, where the court held that registrars cannot exercise jurisdiction beyond their express legal mandate. The effect of this decision, and my Lord, Your Honor, I'll furnish court with a copy of the decision. At the rise of court, it's there online. Your Honor, it's online, so you can check it out. It's online. Your Honor, the IT specialist can confirm that there is internet in court right now. Most obliged. The judgment emphasized that any action taken by a registrar outside his or her bounds is null and void ab initio. And I already stated that not even an order of court can confer delegated powers. To that note, Your Honor, I appreciate your expressed desire to hear the sureties. I really appreciate. This matter has been adjourned severally, like counsel said. But in the interest of maintaining the integrity and legitimacy of these proceedings, it is in order that the law be followed.
I want to paraphrase. Instead of saying, I found the desire.
I beg your pardon?
I appreciate the express desire. That I have express desire by the religious. So I'm not acting under instruction, but it's my desire. You're not.
The word.
The court.
How did we rephrase? I'm trying to think. But I appreciate the express. Your availability. I could use the word availability.
It's the court.
You know, I would wish to distinguish the court, the judge, and the court, the registrar. Because that's now where the gist of the discussion is. I say this respectfully, Your Honor. I'm not trying to. I'm just concluding my prayers so that we get into. Yes, like I said, I appreciate the express availability of you, the Honorable Registrar, to receive the particulars of the sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his own bail application in regard to the legitimacy of the proceedings. It is the applicant that will suffer. I really want this matter disposed of as quickly as yesterday, but in the right way. In the right way. I so pray, Your Honor. She associates with my submissions. Maybe the clerk can first reiterate what I was saying before counsel stands with the applicant. We'll do it.
The applicant is due represented by 6 lawyers. That should not be his worry. Your Worship, first and foremost, I am baffled by submissions of my land counsel and land state attorney, senior state attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very important issues to note. The court has specifically stated that it is here to receive on the sureties for identification as directed by the trial judge. Your Worship, I want the court to not try your judge. The trial judge is everly known in this matter. And my land friend has considered everly that the trial judge gave directives. Unfortunately, is not here either on health grounds or other grounds, and has issued a directive to that effect. It's unfortunate, it's baffling that my land senior state attorney, who has practiced before this court, cannot appreciate the administrative nature of these courts. Your Worship, the land senior state attorney has stated that section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that that is the position. However, Your Worship, you're not sitting here. In fact, the courts, as near as possible, have always adopted a procedure under section 14 2C of the Judicature Act in as far as section 14 2C of the Judicature Act. In circumstances where there is no proper procedure and the court is enjoined to promote good.
Can you read the section?
Most of them.
No, I think let's use off the microphone.
That section, Your Worship, is to the effect that where there are no express law or rule is applicable to any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience, the court is enjoined to adopt a procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case a bail application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is a fortified submission that you are ably in charge of the directive of the land trial judge. You're not sitting as a court to hear a bail application. The land state attorney has stated section 43(2). Equally enjoins this court to give such directives in order to achieve the ends of justice. Your Worship, the land state attorney has relied on the case of Rebel Enterprises to claim that This is a matter where you're sitting as a registrar to hear the matter. We disagree first and foremost. In the lawful enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court said, no, you do not have such jurisdiction. This is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submissions of my land state attorney should have arisen at the time of an appeal, in case he wants to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Mr. has something to say.
May it please Your Worship, I'd like to emphasize section 43.2 and read it in verbatim, that talks about officers of court. And it states as follows.
Section
43.2 of the Judicature Act. 43. Subject to Article 133 of the Constitution, the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43.1 states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the Chief Registrar, Registrars, Deputy, etc. Your Worship, when we are here, states can also attest. Just a second.
I just want to get clarity. The provision is reading, I want to be sure that we are in sync of the provision. Because the 43 is reading is not the 43 I see in the 7th revised edition. I just wanted to be maybe clarifying that. We seem to be reading different laws.
It's clear here that where in any case no procedure is laid down for High Court by any written law or by practice.
Council, what section are you reading? Because you are putting that wants to ascertain.
Section 43.
Of the laws it is.
Of the laws it is, Your Worship. And in any case, Your Worship, my land colleague clearly stated that this court has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own volition. And you stated that immediately you had entered. Your Worship, you clearly stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions because they have theirs in reply. Meaning, Your Worship, that even a mere giving of date, he will object because you're not, in his opinion, the trial judge. And he would say that that would be a faulty procedure by his own assertion and submission. In our opinion, Your Worship, you're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court, most obliged.
Your Worship, just one thing, because the land state attorney relied on Bravo Enterprises versus URA. Your Honor, first and foremost, of course, that was equally a civil case, but this court equally is enjoined under Order 51 of the Civil Procedure Rules to entertain interlocutory application. Your Worship, we are not saying you're entertaining an interlocutory application, but this is an interlocutory application that you are equally mandated under Order 51 of the Civil Procedure Rules to entertain. Because this is a bail application arising out of the main case. So, Your Honor,
I don't want you to bail us, just to go elsewhere.
most of them. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync with you to receive the sureties as the court has decided. The trial judge has not divested himself of the powers to entertain and determine the application for bail. That one is not anywhere in the law. Secondly, the trial judge has not directed you to determine the substantiality of the witness, of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in the position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the land state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at.
Can we have the joiner?
Your Worship, if you so wishes, but I don't think that it has them.
I'm most obliged, Your Honor. I begin with the submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I prayed to make
I said
response.
don't play court, so it is not going to play court. So, put some other.
Who will guide it, Your Honor? Your Honor, this matter has been captured on the record.
And it has been captured that is very important in certain establishment.
Your Honor, I don't mind that you don't record it,
Okay.
but I pray that I still bring it up. Most obliged. My brothers submitted that this Honorable Court by Order 51 of the Civil Procedure Act has the powers to entertain this application.
That's not what he said, but say interrupted application and he was referring that this is an interrupted application. Okay?
My Lord, it's actually the same argument.
The same argument. It is overruled that this court cannot entertain interrupted application on no matters. Proceed. I am going with your objection.
And on that overruling, on that ruling, this is an interlocutory application. A bail application is an interlocutory application. And as court has rightly ruled that it does not have power to entertain, sure, it does not, and I agree with it. My brother has continued to submit that the court, as it sits now, is merely hearing the application, not determining the application.
But that's not what is on record.
Your Honor, they said
The court is receiving, Your Honor.
the record is clear. We can always get a certified copy later, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it, it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Nsereko, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submission. And there is no practice I brought to the attention of court that has been adopted before. You know that there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns the matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section 14(2)(c). And I would first want to read it verbatim and I make an explanation thereafter. So section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with the written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter, in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter, in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't. As far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does conscience require in the instant case? What does it require? What does justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way. So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined. No, my lord, I could, counsel, you are not going to divert me.